Good evening, Prof. Yukin. I'm Gerald Smith, and this is the procedure to commence an appeal. So, firstly, who can appeal? Well, of course, the first person that can do an appeal is the plaintiff, which is the person who initially filed the suit. Then we go to the defendant, which is the person who are sued by the plaintiff. Then they are the appellant. The appellant are the party who had filed an appeal but are left dissatisfied by the judgment of the court and wishes to appeal to an even higher court. And then lastly is the respondent, which is the other party that's involved in previous appeal that are now being taken to an even higher court by the appellant. Well, what are the conditions to commence an appeal? Of course, firstly, a party can only appeal a ruling or a judgment of a court of law. If the court has not yet made a decision on the matter that was discussed, there cannot be any appeal being done. Secondly, the appeal must be filed within the mandated time frame, which in the case of a high court decision, the appeal must be filed within 14 days of after the decision was given by the court. Thirdly, the appeal is not against the decision of setting aside judgment in default, dismissing the application for summary judgment or striking out. And lastly is the appellant must follow legal procedure, which is firstly a filing of notice of appeal in the court that issued the judgment they intend to appeal. What are the procedure to an appeal? Of course, an appeal is based on the previous court's judgment, which either the defendant or the plaintiff being dissatisfied by the judgment of the court. Then they want to bring their case and appeal it to an even higher court. Of course, this will be followed by the notice of appeal. The notice of appeal shall be brought within 14 days from the date of the decision that this decision appealed from, which is stated in Rule 2, Order 55, Rule 2 of Rule of Court 2012. Then this notice must come with grounds of judgment and the notes of evidence. Then there will be the memorandum of appeal, which is provided in Rule 18 Clause 7 of the Rule of Court 2012, whereby the memorandum of appeal shall be filed with the registry of the Court of Appeal within 90 days from the date on which the decision appealed against was given. And the same thing will go on with the record of appeal. Then after all of this done, then we'll be going into the hearing process of the appeal, where the appellant and the respondent will be able to talk about their case, present their case and receive the judgment that they wanted.
Good evening to Prof. NURUL Ashikin. My name is NABIHAH binti ANUAR. And today I'll be presenting on our assignment, which is the procedure to commence an appeal in the civil case by referring to the Order 55. So moving on to the issue of the case, as we can see here, there are two issues in this case. The first one, which is the issue of whether Ratu can successfully appeal for an increased amount of damages from RM 300,000 to 410,000. And the second issue of the case is whether Naila can successfully appeal on the grounds that Ratu was contributory negligence, thereby reducing Naila's liability.
Hi and a very good afternoon to Professor. So my name is EVIANA LINUS and matrix number is 012023020152. So today I'll be explaining about the rules in this case. So basically there's no definitions of appeal in the rules of Code 2012. However, an appeal is a legal process that allows a higher court to review a decisions made by a lower court. So the higher court may affirm, reverse, or vary the original decisions by the lower court. or in other words, it is an application to a superior court to review or reverse or set aside the judgment, order, determinations, decisions, or award of any inferior court on the ground that it was wrongly decided and requires to be corrected. Meanwhile, decisions is defined under Order 55 Rules 1, where it stated that decisions include judgment, order, and decree. Under Section 3 of the Court of Judicature Act 1964, it stated that subordinate court means any inferior court from the decisions of which, by reason of any written law, there is a right of appeal to High Court, and means in relations to High Court, and such court as by any written law has jurisdictions within the local jurisdictions of the High Court. Next is Section 27 of the same Act, states that the appellate jurisdictions of the High Court shall include the hearing of appeal from subordinate court. However, it must be noted that Sections 28 of the same Act impose certain limitations to Sections 27, where in Section 28 state that subject to any other written law, no appeal shall lie to the High Court from a decisions of a subordinate court in any civil cause or matter where the amount in dispute or the value of the subject matter is 10,000 ringgit or less, except on occasions of law. Sections 28 Clause 2 stated that an appeal shall lie from any decisions of a subordinate court in any proceeding relating to maintenance of wife or children, irrespective of the amount involved. So, the above mentioned provisions, which is subsections Clause 1, impose limitations of appeal from the subordinate court to High Court, where except when there is a question of law in appeal, the amount dispute must not be less than 10,000 ringgit. Otherwise, there would be no right of appeal. Next, we move to the procedure of appeal. So, the procedure of appeal to the High Court from subordinate court on a decisions after trial is set out in Order 55, Rule of Court 2012. However, it must be noted that, like what I have mentioned before, when it comes to procedure of appeal from subordinate court to High Court, limitations of appeal as stated under Sections 28 of the Court of Judicature Act 1964 must be complied with. Rule 2 of the ROC 2012 stated that all appeals to the High Court shall be by way of rehearing and shall be brought by giving a notice of appeal within 14 days from the date of the decisions appealed from. Next is Rule 3 of ROC 2012. It stated about the notice of appeal against a decisions made after trial, where in subsections 1, it stated that the notice of appeal must be in Form 111 and shall be filed in the court from which the decision is appealed from. Next is an appellant may file an appeal from all or a portions of a judgment or order, and the notice of appeal must specify which portions of the judgment or decisions is being complained of. This is to make it clear to the judge on the scope of the appeal. And also stated under Order 55 Rule 3, subsection 3 of the same Act, at the time of filing, appellant shall lodge in the court appeal from a sum of 1,000 ringgit by way of security for the cost of appeal within the time limited for filing. And apart from that, the appellant must also apply to High Court in writing for the notes of proceeding and the ground of judgment as stated under Order 55 Rule 3 subsection 5. It must be noted also that the appeal to High Court on a decision of the trial shall be made in an open court. And not to forget that the copy of the notice must be filed and served to all respondents within the time limited for filing. That's all from me. Thank you.
Assalamualaikum and hi madam, my name is SYAFIQAH NADHIRAH binti Yaakob. So today I would like to presenting on the rules of this IRAC. Basically we use order 55 rules 4, which is for the rules for subsection 1, which is the preparing and filing of record of appeal. So basically if the appellant would like to appeal the case in the High Court, they need to be done within 1 month only. If they do after 1 month, they are not allowed to do so. So for the filing, there are some document needed, which is such as like relevant pleading, notes of evidence, ground of the judgment, the memorandum of appeal, the decision, order or judgment made by the trial court in the session court, and last but not least is the exhibit. So all of this document is essential in order to appeal the case in the High Court. Okay, moving on to the rules for subsection 1, which is this is the supplementary record of appeal. So basically this is such as notes of the evidence or the ground of judgment is not ready within the prescribed time. The appellant can be allowed, which is can be filed a supplementary record once they are ready. This can be done without seeking permission from the High Court. The appellant also can file the supplemented memorandum of the appeal if it is necessary. So this rule is to ensure that the process is not delayed within the time. Okay. Moving on to the rules for subsection 3, which is the memorandum of appeal. So basically the memorandum of appeal is such a document in the appeal process, and it is set out the ground of object to the trial court decision. And last one is rule for subsection 4, which is draft index. So basically the draft index needs to be sent by the appellant solicitor to the respondent solicitor within 48 hours for two subject exclusion or any exclusion to the document from the record of appeal. So if they are failed to do within 48 hours, they are not allowed to do so. Next, I will continue presenting on the rules for subsection 5 in the next slides. Okay, moving on to the rules for subsection 5. So basically this one, if one party are not agree with the document to be included, the rules for subsection 5 is provide the procedure where the matter will be referred to the register of the High Court, where the registrar will require the parties to attend before a judge resolve the dispute. Okay, and this rules is to ensure that documents in the record of appeal are relevant and also appropriate for the appellate court review. Okay, moving on to the rules for subsection 6, the exclusion or irrelevant document. So basically this one is important form the record of appeal, where the registrar and the parties are required to work together in order to ensure that they provide the relevant document and also avoid for the unnecessary or any duplicate document to be bring to for the appeal. Okay, moving on to the rules for subsection 7, objection to the document. So basically this one is to address the situation where one party object to the exclusion or of the certain document that are unnecessary or irrelevant. If the party is insist on including them, the final record will be indicate that one objection was raised, and it will be also notes which one party instead on the document exclusion. And lastly is rule 4 subsection 8, which is this one is required to the appellant need to serve a copy of record of the appeal to the respondent within the limited time. So this is to ensure that all parties involved in the appeal case are fully informed and have access to the necessary document needed. So yeah, that's all. I will continue presenting on the rules 55, rule 6 in the next slide. So next I will continue presenting on order 55 rule 6, which is list of appeal. So basically this one is when a notice of appeal is received under the order, the registrar need to enter the appeal in the list of the appeal that originate from the subordinate court. This process is essential because it is ensured that the appeal are formal record and the appeal court can track the progress of each appeal. Okay, moving on to the rules, order 55 rule 7, which is this one is the restriction on the fresh evidence. So basically when the any parties would like to bring the fresh evidence, they are not allowed, but the judge will be allowed with the two conditions only, which is first is the new evidence was not available to the party seeking to use it during the trial at the subordinate court. This could mean that the evidence only become available after the trial, or it was not reasonably obtained at the time of the trial through the reasonable diligence. Second, the fresh evidence is true would like to have in the appeal and had to determine the influence on the decision of the subordinate court. This means that the new evidence should be substantial enough to impact the original decision. Okay, so if the others, then these two conditions is not allowed to bring the evidence during the appeal. Okay, moving on to the rules 55, to the order 55 rule 8, which is notice of cross appeal. So basically this one is a respondent in the appeal has the right to file a notice cross of appeal if they wish to challenge the decision of the subordinate court, but in others different ground from the appeal. So the notice of cross appeal must be filed within 14 days from the date of the record appeal. So they need to use form 113. So basically this cross of appeal give the respondent an opportunity to present themselves on the agreement for why the decision should be verified, and even if they do not fully agree with the appellant grounds, this can be ensured that the respondent have the fair opportunities for the judgment. And lastly is rule 9, which is the amendment. So basically the High Court have an authority to amend the memorandum of appeal or notice of cross appeal or other parts of the record of appeal on such term as if they think it is fit to them. This amendment is necessary due to if there got some error, if there got new information to add, or Any clarification needed after the insertion filing of the appeal? So that's all for the rules. Next, my friend will presenting on the application of this case.
Moving on to the case law that we found it related with the case of Ratu and Naila. The first case is Siti Atira binti Muhammad Sapwan against Razanatul Ain binti Hassan and another. And this case was happened in 2015. The issue of the case is whether the appellant guilty of contributory negligence and was the trial court's apportionment of liability 50-50 correct. The facts of the case are Razanatul Ain binti Hassan, the first respondent, was driving a car when she collided with Siti Atira binti Muhammad Safwan, the appellant who was riding a motorbike. Initially, the trial court attributed contributory negligence to the appellant, presuming that she was speeding and ruled both of the appellant and the first respondent were equally liable 50-50 for the accident. And the judgment of the court was the Court of Appeal overturned the judgment of the trial court and found that the first respondent was fully accountable for the accident as there was no contributory negligence on the appellant side. The court emphasized the distinction between contributory negligence and negligence. Contributory negligence is the failure to exercise reasonable care of one's own safety, which contributes to the accident, whereas the negligence is the breach of a legal duty of care. The court also cited Section 12 of the Civil Law Act 1956, which allows damages to be allocated according to the claimant's share of responsibility. The Court of Appeal found that no contributory negligence. The Court of Appeal ruled that the trial court's judgment that the appellant was speeding or otherwise negligent was not supported by enough evidence. The respondent liability was also determined that the first respondent was entirely responsible for the accident, as the court stated that the respondent's car's damages that is apparent in the photo fail to prove that the appellant was speeding. And the last one, which is the reasonable speed. Based on the evidence, the appellant was travelling at a reasonable speed for the situation, approximately 50 km per hour, while riding her motorbike. Moving on to the next case law, which is the case of Ahmad Zulfandi bin Anwar against Muhammad Shahril bin Abdul Rahman. The issue of the case is whether the absence of a valid driving license, road tax and insurance automatically increases a driver's contributory negligence in a motor vehicle accident. The fact of the case is the respondent, Muhammad Shahril, a car driver, and the appellant Ahmad Zulfandi, a motorcycle, collided in a car accident in Perak on December 15, 2017. Ahmad Zulfandi claimed compensation after suffering serious injuries. However, at the same time of the collision, he lacked a valid driver's license, road tax and also insurance. The Court of Appeal overturned the Session Court's original liability apportionment and overruled the High Court decision in 70% of the liability is on the respondent, which is Muhammad Shahril. 30% of Ahmad Zulfandi, which is the appellant negligence, was contributory. The appellant pertaining to quantum, the total amount of compensation was dismissed, and lastly, the general damages granted to the appellant, which included 50,000 for loss of earning capacity, were upheld by the court. In terms of negligence and contributory negligence, in accordance with Malaysian law, a breach of the duty of care, causation and damages are required for liability in road accidents. The Road Transport Act (RTA) of 1987 stated that even though the RTA regulates administrative violation like driving without a license, they do not typically constitute liability in civil cases. The Court of Appeal ruled that the absence of insurance a driver's license or road tax has no direct influence on whether contributory negligence is established in a civil case. Liability should be determined by the conduct and acts of the person involved at the time of the accident. And also the court emphasized that the tortious duty of care is distinct from administrative violations under the RTA itself.
Hi, Assalamualaikum. My name is ROSMAWATI MASALAN. Okay, on this task, I will present about the applications for RATU appeals in the Court of Appeals. Alright, and there is 2 points for the ground of appeal that RATU can use. Alright, the first one is consider on the failure to consider an evidence. So the second one is Ratu can mention about the issue of error in applications of law. So now let's move on to the explanation. So the ground of appeal that Ratu can apply is failure to consider key evidence. So in this point, Ratu may argue that the trial court failed to adequately account for her critical aspect of her damages. So in this situation, Ratu, in this situation, the evidence that can be considered is medical expenses, long-term rehabilitation costs, loss of future earnings, and also non-economic damages like pain and suffering. Alright. So, for example, if evidence of sustainable medical bills or an expert report detailing on Ratu cases, this can present to the court and reflect on the judgment. So it will strengthen Ratu cases on her appeals. So the second one is Ratu can mention on the issue of incorrect applications of law. So in this case, Ratu might assert that the trial court misapplied the principle governing the calculations of damages. So in this term, she can issue about the terms of multipliers, multiplicand. So in these terms, it's approach for the futures losses. So the relevant case, there is two cases here that can be related to Ratu cases, which is the first one is the case of Tan Kim Chuan against Chandu Nair and others, 1978, which is in this case involved a claim of damages arising from personal injuries. So the trial court awarded damages for medical costs and pain and suffer, but failed to account for loss of future earnings. So the court judgment state that the appellate court increased the damages, ruling that the trial court erred into not considering all relevant factors, particularly the losses of income. So the second cases is case of Abdul Hamid Muhammad against Muhammad Zain 2004. So the fact of the case is the plaintiff sought increased damages after being awarded an amount deemed insufficient for his injuries sustained in a motor vehicles accident. So the court held that the appellate court intervened, and then also it's highlighted that the trial court award was manifestly inadequate and failed to reflect the gravity of the injuries and their long-term impact on the plaintiff's life. So, in Tan Kim Chuan cases, the appellate court increased the damages after finding that the trial court had failed to account for loss of future earning. This established the principle that court must consider all relevant factors in awarding damages. Right. So the second cases, the cases of Abdul Hamid. In this case, the appellate court intervened when the trial court awarded was deemed manifestly inadequate. So this case underscore the appellate court willingness to revise award when clear error are demonstrated. So in this case, the appellate the appellate court cautions about the interfering with damages unless the award is manifestly inadequate or based on legal or factual error. So rather chances of success his appellate is appeal is will get the chances if she present all the evidence related to the medical expenses, uh, clarifications from any expertise that stated that she can the capacity on her earning in future is decreased because of the damages. So now let's move on to the how Ratu can the step of Ratu can make an appeal to the appeal court. Thank you. All right. This is the relevant procedure under Order 55 of the rulings of court. So if Ratu want to appeal her case, so she need to follow all these steps to make an appeal. So the first things that she should do is filing of notice of appeal, which is she must file a notice of appeals within 30 days from the date of the judgment or order being appealed. And also, the notice must state the ground of appeal briefly but clearly. Like what I mentioned before, she need to mention on what issue that she want to argue. So the second step is preparations of record of appeal. In this step, it's including the judgment, pleading, evidence, and also submission relied upon during the trials. So the appellate must ensure the proper explanations and also indications of all documents that she need to present on the day she want to submit the Court of Appeals. So the third one is service, right? So the notice must be served on the respondent and any other relevant parties involved. So the fourth one is filing or writing submission. In this step, the applicant must submit detailed written argument, outline the legals and also factual error made by the trial court. So the last step is hearings of the appeals. The appellate court will schedule a hearing date to consider the merits of the appeals. So in this case, if Ratu want to proceed with her appeals, she must comply with the procedural step under Order 55, including filing a documents of including filing a notice of appeals within 30 days and also preparing all record appeals and also submit the evidence and also written submission outline to the trial court. So if Ratu want to appeal her case to seek more compensation, she need to follow all the steps so that she can make an appeals. So that's all for me. Thank you.
So the application for NAILA's appeal. So what are NAILA's ground of appeal? So NAILA's only ground of appeal in this case we can see is the contributory negligence. So in order to prove this, NAILA must prove that Ratu's action actually contributed to the accident. She must convince the court that there is shared liability on behalf of Ratu that causes this accident. then she must prove that Ratu failed to take reasonable care that led to this accident. So what if the contributory negligence is found by the court? Well, then the court shall apportion the liability between the parties. For instance, if Ratu is found liable for 30%, then her damages will be reduced by 30%, which will lower the award to 210,000. And we can refer to the case of Ahmad Zulfandi bin Anwar against Muhammad Shahril bin Abdul Rahman 2022 for MLJ 892, which is presented by my colleagues, which said the legal principles that are applied in this case is that in accordance with Malaysian law, a breach contributory negligence are a breach of duty of care, causation and damages are required for liability in road accident. Which means if Naila were able to prove and convince the court that Ratu have her part in this accident, which either will be she's either speeding or playing with her phone, the court may found Ratu is liable for contributory negligence and shall lower the award and apportion a liability between the parties. That's all from my part.
To conclude, the court may first uphold the original judgment. The court might decide that the trial court's judgment was right and uphold the 300,000 award to Ratu. However, in the circumstances that Ratu is successful in demonstrating the insufficiency of the initial award, the damages could be increased to 410,000 as per requested by Ratu. Second, the court may reduce or dismiss the award. Should Naila demonstrate contributory negligence, the court has a choice to either reduce the damages or dismiss the claim completely. And the last one, the court may address Naila's cross appeal. If the appeal court decides that Naila's arguments have merit, it might modify the decision due to the facts of her cross appeal. Also, we have to note that each party's appeals, merits and procedural correctness will ultimately determine the appeal court's judgment. Order 55 guarantees that the parties' appeal are appropriately considered and taken into consideration, resulting in a just and equitable decision.